gotten to, but maybe somebody could try and find one. That seems like a camera issue. Okay, so that's great. So the as proposed in the memo, which you just voted aye to, the contract won't start until January, which is when I think we're really going to open the floodgates and start making forward progress. Great, thank you. It also gives us a couple of months to thread our way through the state contracting requirements for a single source. So we have some admin items to discuss.
Is that a Franklin Trust?
And we also have the ERA study. We could go through the admin items fairly quickly if they don't require much discussion, and then use the remaining time before lunch to try and complete the ERA study.
Good.
Okay, so we did election of officers, meeting schedule, memo 2335 and its first supplement. Everybody situated? So the main memo presented a proposed calendar for 2024 and acknowledged that it was hard to know exactly how frequently to meet or for what duration, because we didn't know the extent to which we were going to be able to use Zoom teleconferencing. There were some balls in the air legislatively. Those balls have landed now. And the first supplement describes the result, which you should take into account before making a decision on like how frequency and duration of meetings, whether to approve the calendar. And then also notes that Commissioner Carrillo requested one change to the proposed calendar. We could take that into account when we get there. Discussing the first supplement, one thing that happened was a budget trailer bill was enacted. Budget trailer bills have immediate effect. It extended the flexibility that allows us to meet entirely by teleconference. We could have done that today if it hadn't been that we were all meeting in person for other reasons. So December, it's available as an option. We don't have to have a hybrid approach, which I think works, but actually is, I think, a lower quality experience than the meeting entirely by teleconference.
And more complex.
Yeah, more complex, more potential ways to fail. Requires commissioners to find spaces that are open to the public, whether domestically or internationally. So the first decision point is, are you, and I'm not going to call roll on this, is just pure administration. Are you okay with us doing teleconference, a wholly teleconference meeting in December?
Yeah.
Yes.
Yes, and a point on that. I like in-person meetings, but they're expensive. And I'm sensitive in tough budget years to the travel expense that flying us up here every month entails.
Yeah.
It's kind of 6 and 1 for me. Like in Berkeley, I can drive up here. That's not a big deal.
Yeah.
But like you, I often travel. Like in December, I'm going to be in Tokyo again. So
Cheap flight.
you're right. So if I'm here, it's easy for me to drive up here, but sometimes I can't.
So the other news is that Senator Laird's bill, SB 544, was enacted into law. It was substantially amended after we first saw it, to the point where I think it worsens the obstacles to meeting by teleconference. I'd say the most critical problem for us is that there is a requirement that a majority of the members of the body be present in a single physical location, which for us means, if we're saying majority of the members rather than majority of those present participating, is 6. And 6 is often how many members we have.
Yeah, that's almost everything.
So if that's construed strictly, and as I say in the memo, there's a constitutional provision that requires us to construe public access issues strictly. I think we're under that procedure, we're stuck having to have 6 people in one place, which means teleconference, except at the margins, isn't really going to be workable. They also, the bill approved a special procedure for advisory bodies, which is quite similar to Senator Laird's original conception. So I think what happened is his original bill idea got limited to a specific context, advisory bodies, and then this stricter procedure got added to it.
Are we advisory?
I don't believe we are. It's not a defined term in the bill, but there is another provision in the Bagley-Keene Act that uses exactly the same language. And in that provision limits it to advisory bodies created by the body. So like if we created an advisory subcommittee, that would be an advisory body, but I don't think we are.
Got it.
We could try to make that argument, but again, the Constitution says construe the law strictly in favor of public access. So I don't think that's available to us without being on thin ice. But the good news, and this is ironic, the good news is that the bill specifically preserves the option of proceeding under what is now existing law, which so the thing that this bill was intended to cure remains available as an option. And so we can do what we did at the last meeting if we want. We can have hybrid meetings where we meet here with at least one commissioner, and any number of other commissioners can be in remote locations so long as they're agendized and held open to the public.
Okay.
So like a meeting room in a university or a law firm or something, as long as it's open to the public, they can participate in the meeting from there. So I say,
And they want to go to Argentina.
yes, that too. Or Japan. So if we continue to do hybrids, we can continue to do them as we have been. It will be permitted. Disappointing result for that bill because it just didn't give us any more flexibility than we already had. So that's another decision for the commission to make is, do you want to use hybrid? One of the advantages of having a physical location like this is that it enables us to hear from people in remote locations like we did this morning. They're not members of the body, so they're not subject to the constraints of the Open Meeting Act.
We can still use this location if we're doing a hybrid meeting, right?
Correct.
Yes, presumably, yes. I have hinted at that to the Legislative Council. I don't expect that they would withdraw it.
Okay.
Um,
So.
Or if everybody wanted to drive to Berkeley, we could use one of your classrooms.
I'm happy to.
Yeah.
That's, again, like, we're joking about it, but I have made that proposal before. It's fairly easy for me to reserve space. I just need a little bit of advance notice.
Yeah,
There'll be some blackouts like during finals and things like that, but
yeah,
we have very large rooms.
it just imposes additional travel burdens on folks from
It
here,
does.
Commissioner Simpson, Commissioner Jenkins.
Yeah, so.
It'd be,
It's an option on the table if.
Yeah.
Folks need it. So basically what we're talking about is we can still do what we did last time, right?
yes, we can still do what we did last time and what we did 2 years ago when there was this little hiatus in,
Was it one of the Sheratons?
yeah, in the Sheraton. That was not great. This is better.
Yeah,
And this is free.
We have tech support here,
yeah.
which is
Yeah, it fixed the problem. That's great.
for the hybrid option for those of us in Los Angeles. I'd like to make a suggestion because Victor and I were talking about finding locations. It is really tough.
Yes.
Most entities don't like being posted that there's a public meeting. However, there are state office buildings in downtown LA. I'm wondering if the commission staff can approach those state office entities in LA that perhaps may be able to host us, because then that's better. It's open to the public, it's a public building. That would be my suggestion and request, please.
Yeah, I think it's,
In the past.
we've done that in the past,
Yeah.
Buildings.
not for the purposes of a remote teleconference
No,
location.
but we've had
in state
meetings in
buildings.
state
Yeah.
The state bar building in downtown LA might have a good county building.
So we've met in local government agency buildings too, the airport authority, the port authority. So yeah, we can look to other public entities and see if we can find good space for remote locations in LA or San Francisco.
Yes.
And
I'm happy to do my
it doesn't,
work in San
it doesn't have to be downtown LA. Downtown LA, very inconvenient.
Yeah.
Parking's absurdly expensive, but
Yes.
just to the east of downtown, there are a variety of municipalities, including Pasadena, that have both county and municipal facilities. And they're probably going to be a little more receptive than some of the bigger offices downtown.
Courts too. We met in the LA airport courthouse.
Yeah, and there's a court in Pasadena.
Kristen?
I was gonna mention is libraries. We've met in public
Met
libraries.
in the library in San
Oh,
Diego.
nice.
I don't live in Pasadena, by the way.
You're not advocating. for-
No.
A condo.
Yeah,
Small.
so it's workable. We can make it work. And the staff, I'm happy to impose a burden on them. Can
Especially since you're leaving.
As you're.
can do the,
Swan song.
they can do the legwork to set it up. If you just tell us, sort of what is your ideal. I know Commissioner King's in the Burbank area, and I mentioned the Port Authority. I think the Port Authority building, which is awful, was in Burbank.
Oh, right by the.
Aesthetically awful. It was fine as a meeting space.
And
So there's-
we did hotels too. Did
Yeah,
one time we did that
That's
for,
right. We used to meet at the Burbank Hotel all the time.
that
It's a little costly.
meeting.
Yeah.
Interesting.
I like this space.
All right, so it sounds like you're leaning towards hybrid.
Yeah.
So then you have to decide with,
It gives us flexibility.
And also, I think my concern is for people who might be low income or have inabilities to travel and do all of that.
Uh-huh.
I think having a hybrid is essential to have a diversity of voices and
Yeah.
perspectives.
Great.
So if somebody wants to come and look us in the eye, they can do that. If they can't, but they still want to watch.
Right.
yeah.
And
So,
just old school, new school.
Right.
Old school commission. We had packed audiences that were
Yes.
very engaged.
Yes.
It's been a little disappointing since I've been back that there's virtually no engagement. Smaller number of people who are on the Zoom and they tend not to interact.
well, you have been back in sort of a quiet phase of the work. I think next year antitrust is going to change from being these sort of scholarly presentations and discussions to more of a free-for-all.
I see.
Mhm.
We might-
And that was the case
I
with
agree.
mediation
Oh my God, that
confidentiality.
was my
which you
first
missed.
meeting.
Yeah.
Sad hotel
Mediation
room, really
confidentiality
steaming
was
against
more
the
than
wall.
half.
No kidding.
So you have to look at the schedule, and given that you're leaning towards hybrid, you have to decide whether you're okay with that schedule, perhaps with the change Commissioner Carrillo requested, and decide whether you want to do every month or every other month. The every month was the practice when we were doing Zoom, for two reasons. One, it was convenient and possible.
Sure.
And there's benefits to continuity of the considerations. And then on the other side of the coin, long Zoom meetings are hard. They wear on you. And so what we found pretty quickly was more frequent short meetings were better. So there's an argument for sticking to monthly meetings.
Especially if you're doing hybrid, Victor.
Can we get the input of the new executive director as to?
I have no idea what she's gonna say.
And official introduction too.
Yeah,
Haven't-
hi, everyone. Sharon Riley, for those of you I haven't met yet. Really happy to be here, and I'm willing to accommodate what works best for the commission. I think that we've heard a lot of perspective about reading public access, and I think that's very important. So whatever works for you all.
I've got a question. Is, in terms of burden on staff, is there any difference with monthly meetings versus like every other month in terms of getting stuff ready for a monthly meeting?
Right.
It's a little hard. When you have a monthly meeting and we try to get stuff out two weeks before the meeting,
Yeah.
you really have a pretty short interval to produce material.
That's kind of my.
Now, you could get creative, I guess, and like alternate, like every other meeting is an antitrust meeting. Every other meeting is everything but antitrust,
Yeah, we don't have to do every subject every time.
right? And then the staff who are producing the materials for those subjects could have a 2-month run.
Particularly because there's going to be so much input
Yeah.
from other stakeholders on that particular issue. It'd be pretty challenging if you've got your information set and then a week before you're getting comments that really require some additional work. Kind of stuck.
Yeah, so if
Yeah.
something's not ready, just take it off the agenda or don't put it on.
Yeah.
Might just be kind of a
I-
different agenda practice, I guess.
I like meetings, but there are scheduling issues with 12 meetings, particularly if a certain number of them are aborted. Because we will have blocked a day
Yeah,
and then there's nothing to do. It's also difficult to block 12 days.
Yes.
So maybe there's somewhere in the middle, but I think meeting every month is too much work for staff and creates potential absenteeism for those of us who have packed calendars. And if we're not getting an efficient and sufficiently high volume of work out of getting together, it's probably not worth all the logistical work to get us together for an inefficient meeting.
So one option,
Agree with you.
since we have December before we have to start meeting next year, and we're gonna be meeting in December, is staff could try to work up a 9 meetings per year schedule. Or something like that, and just present it as an option. You don't have to, what I'm saying is you don't have to decide today.
And then on that, I would advocate for the summer months to be off too. Not perhaps all of July and August, but definitely August. It's just hard in the summertime to.
Yeah. And that's actually helpful to staff too, because we're slaves to the legislative calendar when we have bills that we're staffing.
Correct.
And so the best time for us to plan vacations is the month that the legislature's in recess, which is in July, August.
Correct.
Of course, for those of us who retired every day. So
I've heard that, yeah.
Every day that ends in Y is good for you,
Yeah.
right? My one point is, I'm gonna be out of internet range on February 22nd. So I make personally requesting that we move that to the week before. I think it's the 15th.
And it's Valentine's week. FYI. Not that.
But the day after, right?
Yeah.
People will be sad.
The 14th would be a problem.
Right.
Hey,
I don't know if that creates a scheduling problem for anybody.
No, that's fine. It's
It does.
fine. It's fine.
Well, especially if we go back to the drawing board to work up another
Yeah.
proposed schedule, we
Yes.
could put together a modification of this 12 meeting schedule with your preference incorporated.
Yeah.
And an alternative schedule for 9 or 6 or something like that.
Mhm. Yes.
Kristen?
Just one thing that I'm thinking, I don't know if the commissioners do want to schedule like periodic in-person meetings so that like 1 or 2 would be set aside for an in-person, but I just wanted
For
to.
the gala. People need to retire.
Why don't you all work on that?
Yeah, work on that. Give suggestions.
Okay, so I'm hearing bring this back to the next meeting with the benefit of what's been discussed
That to
here.
me could be a contextual thing, like if we know that something is gonna have like a lot of public involvement, if, you know, like all the FANG general counsels are gonna come and present, that might be worth doing in person. But if we're just doing regular business, we don't really need to be in person for that.
Okay.
When we get to near the end of antitrust,
Yeah.
I think renting a ballroom is the way to do it because it'll be so much more efficient to get it all at the same time. The only thing I would request when you're becoming creative with the schedule, I think you already circulated a schedule, so we put certain dates on the footprint. With the exception of February, I would ask that absent exigent circumstances, we not move off dates that we've
Sure.
all already
Makes
blocked.
good sense. So just a subset of these.
Yeah.
Yeah,
That's a good idea. I'm happy to kick this can down the road.
Not
Sure.
So the last item I have administratively before we get to the substance of the ERA discussion is legislative program, and there's a few different pieces there that are worth discussing. One is, as I reported, Kristen's bill that she staffed on trial court restructuring had it went through some stuff. It started out as its own bill, and then later it got moved into an omnibus bill. And in the process of moving it into the omnibus bill, some provisions dropped out. One of those provisions we're going to seek to reintroduce, so no action required today. It's just something that'll have to get fixed. The other was the bill-wide savings clause that's discussed in the supplement. When we were doing the proposed repeal of these employment benefit provisions for the courts, we were pretty concerned about making extra sure that we didn't inadvertently repeal a statute before it, while it still had application. So this was Barbara's study, and she actually instituted a sort of a 3 layers of protection. One is the repeals were sunsetted 50 years out, to give much more time for people to no longer be subject to their benefits. Then there was a savings clause that said, if there is anybody who's still alive after 50 years, this doesn't affect them. And then there was a bill-wide savings clause that said the same thing, but in a broad sweeping way. The bill-wide savings clause is what got dropped out. We don't think that's a problem in terms of the effect of the law.
Still have
Two
bells
levels
and
of
suspenders.
protection or enough. We have bells and suspenders. We don't need a second pair of suspenders. Or whatever the third thing would be. So the only thing is that some of the comments refer to the code-wide or the bill-wide savings clause. And at the last meeting, we talked about just revising our comments to delete the reference to the code-wide savings clause, or bill-wide savings clause, which did not make it into the bill. So we attached a draft of revised comments to make that change. It was discussed at the last meeting, but obviously not decided because we didn't have a quorum. So all we're doing is striking the reference to this provision that didn't exist. So I would ask for your approval of that draft of comments.
I'll move.
Second.
All in favor?
Because this is modifying our report, I'm gonna call the roll. So Carrillo,
Aye.
Carrion,
Aye.
Cubas,
Aye.
Hebner,
Aye.
King,
Aye.
McAllister,
Aye.
Simpson.
Aye.
Yes, okay, that's good. There was also a problem with the Fish and Wildlife Bill. After it was signed by the governor, another bill was discovered to have conflicts with it, some of the provisions. As is our practice when we do very large omnibus bills, we put in a subordination clause that effectively says, in the event of a conflict, we yield. So in this case, this other bill amended three sections that our bill would have amended. And so either under our subordination clause or under statutory chaptering law, those sections were wiped out. They don't operate. So the question was, and then I should add one other significant fact. Senator McGuire, who was the author of the bill that conflicted, took steps to try to import our language into his bill to save it. So it was gracious on his part. And for the most part, successful. So I'm not recommending that we seek reenactment of our changes. I don't even know how we would do it. It's technically complicated. So ordinarily in that situation, when one of our provisions is extensively modified during the legislative process, we would revise our comments to try and conform our comment to the result in the enacted law. In this case, I think that's not a good idea because the resulting language is complexly interwoven in a way that would be really hard to tease apart in a comment, and the result would be hard to understand and maybe even more confusing. So my suggestion is that we instead just follow our normal practice when provisions get knocked out of a bill, which is to leave our comments alone and just let the legal publishers know these sections didn't get enacted in our form, don't reproduce our comments. Now that's the default, so it's not a change from our normal practice, so I'm not going to ask for a vote on that. I just wanted to let you know, and if anyone had a concern about it, we could talk about it.
Sure.
All right, last point. One of the bills is the bill on administrative subpoenas. I was staffing that bill. The point of this is a trailing piece of our work on electronic surveillance, basically. And the bill would have, or would make clear, require that when a state agency uses an administrative subpoena in conducting an investigation, and it uses that subpoena, it serves that subpoena on an electronic communication service provider, so like Sprint. And it says, produce the electronic communication records of your customer that we're identifying. Okay, when that happens, this law would say the agency has to provide notice to the customer. Okay, they cannot assume that the customer is going to hear about it from the service provider. And if they don't hear about it before the records are produced, then it's operating more like a search warrant than a subpoena, because there's no pre-enforcement opportunity to object. No meaningful pre-enforcement opportunity, because you don't know what's happening. So that the concept is clear, and my research suggests constitutionally necessary that they have notice before the subpoena operates. And so the bill moved along quite well. It got out of the first house into the second house, all the way to the Appropriations Committee, so approved by 2 policy committees in the Senate. And then it kind of stalled out because the California Department of Justice raised concerns. They do a lot of work for agencies, and they also do their own work that involves investigative subpoenas, administrative subpoenas. And they had some concerns about it. And I gave the usual kind of assistance to the author's staff, where, I participated in the discussions to hear what they were saying and ask probing questions to make sure we were understanding correctly what their concerns were. And then sort of informally help the author staff understand their concerns and what the possible ways to respond to them might be. The discussions stalled out. They did not reach a complete resolution, and the clock was ticking for the bill to move out of the committee it was in, or die, or at least have to be turned into a 2-year bill. Because this is the first year of the session, the option exists for things to be turned into 2-year bills where they can continue through the legislative process in the second year of the session. And so my suggestion to the author's office was, you should consider making this a 2-year bill, because I see some merit in what DOJ is saying. And I think it's not, we haven't yet figured out how to address it, but it would be helpful, I think, if the commission had a second bite at the apple and could do an expedited, quick review of those issues with the eye on potentially issuing a supplemental recommendation. And then the author can do whatever they want to do with that, with the result of that proposal. And the 2 issues that they raised, one was they persistently didn't want the law to apply to business entities. They wanted it to only apply to natural persons. I had a hard time understanding where they were coming from. They weren't explaining it so that I could understand, but I think I finally got there. There is, in sort of Fourth Amendment doctrine, a principle that heavily regulated businesses have a reduced privacy expectation in their business records. So like if I'm required to maintain records that I'm required to make accessible to the Department of Toxic Substance Control, they can inspect my business records to make sure I'm compliant, then I can't complain that they're violating my Fourth Amendment rights if they access those records. And I think that's the sort of neighborhood of their concern. And if so, I think there might be a way to draft a compromise that more specifically, narrowly addresses that specific issue rather than just accepting all businesses, because all businesses don't fit into that category. So the other issue was our proposal required the agency to give the notice. They wanted the service provider to give the notice. So instead of DTSC notifying the customer, Sprint would notify their customer, hey, we've received this subpoena. It's going to operate unless you raise an objection. And again, it took me a while to understand where they're coming from. It seemed like they were just cost shifting. But I finally got it when we had a conversation where they explained that in modern electronic communications, things are strange. They're not the model that we assume it is, having grown up when we did, where it's like, oh, it's an email address. It's their cell phone provider and an associated email address. Just give us their billing address and we'll send them the notice. There's just such a multiplicity of electronic communications now. And some of them are sort of stacked in layers of confidentiality. So for example, if I want to get a Google email account, the only thing I need to tell them is another email account.
Right.
I don't have to tell them anything else. They'll issue me one. And so similarly, so they were saying it's going to be hard for us as a person outside of that privity between the provider and the customer to know how to communicate with the customer, especially if there are systems that are sort of designed to be difficult for us to penetrate. Like maybe we would have to have a paid subscription to be able to communicate with this service. Or the example I gave in the discussion is maybe it's Twitter, and I want to send a direct message to the customer to say, hey, we served a subpoena on Twitter to get your records, but they have decided to block all direct messages. So they never get it. And I don't necessarily have a way to penetrate that. Twitter has a way to penetrate it. They have a way to talk to their customers. So they convinced me that there are practical, in the modern communications ecosystem, there are practical obstacles to the agency being the one who gives the notice rather than the service provider. The other thing is the service provider, it's not at all intrusive of the customer's privacy for them to send a message, say, we got a subpoena. If I ask Twitter to give me their billing address for their customer, that itself is an invasion of privacy, and there's process that attaches to that. It's a lower level invasion of privacy. It's probably going to be successful, but it's process, and objections can be raised. And so they were saying it's just a lot easier as a practical matter if they handle it for us. And again, I suggest in the memo, maybe there's a way to finesse that, to say if the provider has a mailing address used for billing purposes, give it to the agency, give the notice, and you can rely on that address without further inquiry. In all other cases, service provider gives the notice, something like that. And so I think that there's maybe ways to split the baby and be narrower in the solution than they have proposed, while recognizing that they maybe have a point. There may be a subset of these problems.
It boils down to we need you to further work on this.
Yeah, maybe.
As a trial attorney and past prosecutor who's issued thousands of subpoenas, I have to concur with the DOJ's proposal to have the service provider be the entity that gives the businesses. You touched right on it about privacy, confidentiality. When I hear of having the request of sending personal information, whether that be contact information, whether that be the address or an email or a phone number back to DOJ,
Yeah.
I think that would be a particular request that they could technically argue, we need a court order for this,
Yeah.
right? So if they need a court order to be able to disclose some of this private information from their consumers, I think that adds another layer of process and another issue to go into further litigation.
Yeah, I mean, we could trump it with a statute. We could say you don't need a court order. But then somebody might argue that there's a constitutional basis for that requirement and that we can't statute around it. Yes.
Is there a distinction in terms of the communications, whether it's phone, email, Twitter, Facebook, between an official business account versus a personal account?
That's what they want the law to reflect, is that there is a distinction and they don't have to worry about giving notice to businesses. Within the service itself, whether Twitter has like business versus personal service, it probably varies by service and provider. So I don't know if they would have if even the service provider would have a clean way of knowing whether the customer is a business or
And
not.
follow up on that, are we talking just about the social media platforms or are we talking about phones?
We're not talking about phones because we're talking about stored communications effectively. If you have voicemail, that would be included. But a streaming phone conversation that you're having, that's a wiretap. You can't get that with a subpoena. So the question is, are you okay reactivating this on a narrow front to try and find solutions to those two issues, to make a recommendation that could then be given to Assemblymember Colrett to decide whether he wants to do something to his bill?
Sounds good.
I
I
move,
think it merits it. Yeah.
do you want a motion?
Sure, let's do it.
All
My
right.
last
Been
motion.
moved,
Yes.
A second.
seconded, discussion, going once, going twice, call roll.
Carrillo.
Aye.
Carrion.
Aye.
Cubus,
Aye.
Ebner,
Aye.
King,
Aye.
McAllister,
Aye.
Simpson.
Aye.
All right, that'll be the decision. That concludes all the admin stuff. We have one substantive study left, which is Kristen's. It's 11:45. Up to you whether you want to try and speed walk it through in 20, 30 minutes.
I'm getting a thumbs up and some.
Whatever you want to
Yes,
do.
got it.
It's your presentation.
It's up to you.
To make it effective. Yeah.
Well, we can get started and if there, at this, we are looking for some commission decisions on the direction for this topic. So that I'm not sure if we'll be able to fully get to those points, but, and we've got a lot of material, although I'm not gonna walk through it all. So we did put the, memos from August back on the agenda for today, and we had a new memo, 2344. I'll walk through 2344 at a very high level quickly and then try to get into the decision point. So first, memo 2344 discusses a very robust discussion that the subcommittee had when we had this topic on in August. There was quite a bit of discussion about religion and third-party harms. And so there's some more supplemental information that I've provided along those lines, including pending federal legislation that is specifically concerned with that topic and federal law. I also made a note about sort of the direction of Supreme Court case law on constitutional issues generally, adopting a history and tradition test and how that's a bit concerning for this topic generally, but also on some of the other specific like religious protections and things, those kinds of issues could be affecting the direction that the Supreme Court is taking. So the earlier memos have focused so far on religious constitutional protections and the federal law. This memo presents some about state. I want to thank Commissioner Carrillo, whose casebook and scholarship were a great help to me in coming up to speed on those topics. I guess my general takeaway, and feel free to jump in and correct me or redirect me, is that California's Constitution contains more religious provisions than federal. And they would generally suggest a greater degree of separation between church and state. Although with the direction of federal constitutional jurisprudence, the room for states to deviate is contracting greatly. So it may be that on most questions about religion, whether or not you are prohibited from doing something due to free exercise or required to do something for the Establishment Clause, the room between those two provisions is getting increasingly small. And so California's ability to sort of require a greater degree of separation of church and state may be limited. The federal developments are relatively recent, and there hasn't been much California case law since then. The one other interesting thing to note about the California constitutional provisions and the case law at the California Supreme Court is that the California Supreme Court has recognized combating gender discrimination as a compelling interest that would justify burdening religion in California, as well as access to medical care regardless of sexual orientation. So those two issues were in cases that went up to the California Supreme Court, and they recognized that those would justify burdens on religion, their exercise of religion. So the memo also includes a brief section on legislative updates. There was a number of bills signed by the governor related to LGBTQ issues and reproductive issues. There have been a few more since those original press releases. Nothing that required, I think, a supplement, but I just want to note that there are a number out there. The memo also discusses specifically one bill that had been described in an earlier memo about the replacement of California's travel ban, and that was enacted, and it was an emergency measure, so it is in effect. In the federal law, there's I mentioned the Do No Harm Act, but there's also a federal law about gender neutrality, and so that legislation is moving forward to require gender neutral drafting in federal law. There's two reports that were prepared by the Williams Institute. I'm not going to be discussing those, but they were based on some of the issues that we looked at earlier, and they provided some additional information. Getting to the very last section of the memo, the prior memo presented decision point, seeking commission direction on some approaches. And I think at that point, we were a little bit too abstract about what exactly our next steps were going to be in this study and what those approaches might look like, because we hadn't actually even talked about what the legal reform might look like. And so this memo tries to take a step back and ask the commission, do we want to pursue a constitutional sex equality provision? Do we want to pursue a statutory sex equality provision? And I provide two different possible ways to do that statutory, to craft that statutory provision. There might be others. Or given sort of the findings that we've made so far, our California law is actually pretty good with respect to sex equality generally. Some of the big effects of the ERA are to bump up the level of scrutiny accorded to sex-based equal protection claims to strict scrutiny. California already does that. Our anti-discrimination protections, the broad ones, are generally, they cover many of the topics that the commission has found are within the scope of this study. Expressly, they list the different characteristics that we found are within the umbrella of sex. So we aren't finding any major deficiencies on the broad scale. Now, one option would be to, do a statutory backstop that is still broad. That would be, that's something that we could do. Or we could simply sort of move to what would be the second phase of the study, which would be to try to find the specific problems in California law without moving forward with a broad sex equality protection. And depending on which of those options the commission wants to pursue, we may need to discuss how that might be crafted and get some more detail on what direction commission wants staff to take. And I'm happy to talk more. I'm kind of skipping around a little bit, trying to move through this quickly, but Commissioner Carrion.
Yes, I'm interested in that broad, the second option. And the reason I'm interested in that broad option is that obviously, Kristen, you have put in so much amazing work into this in figuring out the differences and where there are discrepancies or not. I don't think the average person is going to do that. They're not going to be able to do that kind of research, even with our memorandums, to go into it. So I think it would be more beneficial to the people that this affects to have something that's expressed and clear about the broad principle. I also think that, in identifying the second portion, that's the great part about these phases. It's not we're locked in. I'm assuming that as you continue doing your work and you find specific things, we can figure out a way to address those specific that would not take away from this broader language. So I would suggest proceeding with 2 and 3 simultaneously.
Ambassador?
I have an existential question to ask, which is, you've been buried in this for months.
Yes.
Throw yourself forward a year. Do you see something actually productive that will come of this? And I'm asking that because the message I keep hearing is we're already really on point with all of this. And my concern is if I like the sweater, I don't start pulling threads in the sweater because that always leads to them unraveling. So if you don't see a need to continue because we're already essentially in full compliance with the ERA, which is what started this, I would be concerned about doing damage by proceeding and wrestling with questions that are already settled here in California.
Could I follow up on that? Because it might have informed your response a little bit. I was thinking along the same lines, and to me, the debate is between doing something like Proposition 1 last year, which is effectively a constitutional backstop that codifies existing California constitutional law on procreative choice. And that's one of the express options here is doing exactly that thing in this context, either in the Constitution or in the statute. And there's some value to that. I think the downside is equal protection is one of those things that, because we're in such a good place with it, I would have the same thread pulling concern that we can unintentionally undo something or do something that we regret later. I'm worried about unforeseen consequences. But I also, one second. I was also thinking along the same lines that Xochitl was, which is that moving on to the second phase doesn't prevent us from circling back. Because that's sort of the point of the second phase, is like going and truffle hunting for problems, which we can then come back and propose either the constitutional or statutory provision that would resolve those problems.
Yeah, so back to our lead truffle hunter.
Right.
You've been nosing around in the mud now for months. Have you caught a whiff of a truffle that's worth chasing?
So I would say, on the second option, there were two different ways to approach that. And one is to essentially do a statutory equal protection standard that has the benefits that Commissioner Carrillo noted. But also, it's essentially locking in what we've already got. The second one
Which
was,
isn't necessarily bad.
well, it
As
isn't,
long as we're expressive about only codifying existing law and not changing it.
yeah. But the other option would be to craft a statutory provision that broadly addresses sex equality or sex discrimination rules and makes clear what the scope of sex is for those rules. Now, on the big ones, employment, housing, education, state action, those things are all pretty well built out.
Yeah.
But I did find a number of very specific anti-discrimination rules that are very narrow, that don't have those same broad express scope provisions. So it may be that there are some good that we can do there. I have not looked through those exhaustively. I don't have a good sense of how many there are. That's something I could spend some more time doing if that might be of interest to the commission. It seems like we sort of set the constitutional possibility aside. I haven't heard anyone raise that. I will just note that.
Rick had a point, and then Xochitl had a point, and then we have a member of the audience.
Okay.
I'm just wondering if going through the truffles, I guess, and identifying whether and what they are might better inform the nature of a broader statutory provision. Either, yes, we need one, and here's the kinds of things we need to make sure that it covers.
Yeah,
As
that's
opposed to doing the opposite.
That's sort of what I was thinking, because, one way to look at equal protection is it's a broad principle that treat everybody the same.
Right.
And then we have a number of other constitutional and statutory provisions that expressly single out certain protected categories. Don't discriminate against women, don't discriminate against gays, racial things, all that. And so you sort of have double coverage, treat everybody the same, and also specifically don't discriminate against these particular groups. We might be missing some groups. And I recognize that one downside of my, do no harm, don't do anything approach is that we might be missing some groups.
That's kind of what I was.
Well,
Yeah, so there's a concern about, are there groups that we're missing that we want to add?
the question is whether it's going to be interpreted as this specifically identified groups which are protected now. That means that those are the only
Right.
possible permutations
Right.
that will apply. And
Right.
that would be my concern. So I would certainly encourage you to keep looking and see if there's something else that should be addressed that's not addressed and isn't as specified. Because it could be used as an exclusionary tactic,
Right.
which would be a real harm for sure.
Yeah, so to me, I would fall back on the basic equal protection principle of treat everybody the same. So if there's anybody who's
Right.
not expressly singled out, that doesn't mean you get to discriminate against, left-handed people, whatever.
I'm left-handed.
Yeah.
Come on.
Right.
Do you-
Should be treated the same.
Do you interpret
Yeah.
the
Well, can I-
project
I
that
have a
broadly? Oh, sorry, go
Sorry,
ahead.
so she was.
No problem. So I think to go back into your illustration, I don't see the backstop as pulling a specific thread. I see it as fortifying the hem. I see it as an opportunity to really make it clear to people that have not had the opportunity and may not have the skill set to do the kind of impressive legal analysis that Kristen has provided us to really articulate what the spirit of what we're trying to do. And I understand the argument of double coverage in terms of there being, different avenues of protections. I don't think that, transgender folks of color, non-binary folks of color feel that double coverage in their day-to-day life. I think that while the law may say these things, the actual impact of discrimination and harassment and the ability to use the law to stop that from happening, or in a sense of empowerment, is really disconnected to, like, I think a person's experience. So while I recognize and I agree with you that there is technical double coverage, I think that one of the reasons we are going into this process is not only to acknowledge, great, good for us, California, we're doing good, but we need to do better. And I think that there are opportunities for us to be able to create that backstop language as well as continue searching for truffles.
I'm gonna go to a member of the audience who's been very
Sure.
patient. Can you promote them?
Yeah.
And then
I'll wait. Yes.
Victor also was.
Mr. Richardson, we've promoted you to talking. So if you want to unmute, you can address the commission. This is Christopher Richardson. Hand is up. Maybe I will see what I can do about asking him to unmute. Well, let's hold on.
Anna, do you want to go and then?
Yes,
Victor, you wanna go?
Victor had it.
Since
No, no, go ahead.
since the existential question came up, my question is, can we go back or maybe take us back to what was the intent and spirit of what we are supposed to study and recommend?
Good.
Yes.
So our resolution, a lot of the prefatory language was talking about the history of the Federal Equal Rights Amendment. And so it seems like that was a major driver in this assignment. The actual language of the assignment to the commission does not specifically cite to the Equal Rights Amendment. So the operative language is actually reproduced on the first page of the memo, that the legislature is authorizing and requesting that the commission study report on legislation to revise California law to remedy defects related to the inclusion of discriminatory language on the basis of sex and disparate impacts on the basis of sex upon the enforcement thereof. So there's like those two specific things. We're looking for any sort of or disparate impacts. And so those would be the specific things that we would be looking for. Like I said, this was certainly informed by and to advance the efforts around the Federal Equal Rights Amendment. That was clearly a big part of this, but the actual language of the assignment doesn't.
Brian, how would you interpret that then? Because you're very good at parsing out what the legislature tasks us with and what you feel is really within our bailiwick.
I think it's hard to know. The focus is really on the ERA. It feels like this is a resolution about enabling California to be ERA ready. But when you look at the ERA, its effects are mostly federal. They're about federal equal protection and they're about the jurisdictional reach of the US. So the idea of placing California into a position to enable that feels inapposite to me because it's self-executing authority into the US Constitution. So we sort of thought, and then they shift from the sort of prefatory language to very specific language about looking for discriminatory language and disparate impacts and that kind of thing. And so it goes from the very broad and kind of amorphous down to the very narrow and specific. The way we construed that at the outset was, well, maybe this prefatory language is about, let's try to establish within California the same effect that the ERA would have in the federal government. Understanding that we're already most of the way there already, we decided to start looking at whether there was a need for this broad non-discrimination principle to act as a backstop.
But non-discrimination within the confines of sex?
Yeah,
Yes.
that was going to be my question.
Because
exactly.
that's what I mean about the being clear on the scope. I didn't interpret it as a broad invitation to look for other disadvantaged groups, as valuable as that is.
Correct.
We're focused on sex, and my concern is Justice Gorsuch provided a gift. And I would hate us to inadvertently soil that gift by proceeding if there's a risk that the outcome will be, well, that was Gorsuch. We're really just focused on biological women who were assigned female at birth. I would view that as a significant step backwards and an undoing of generations of LGBTQ people's work.
I don't think we can do that because, I mean, the law already defines what sex is, right? To include those diverse characteristics. I mean, we've talked about like sex including LGBT, right? So that's the law right now. So I don't think we would be undoing it. I think that we are articulating it. That's what we're doing with the backstop. And putting it concisely in a way that's accessible to other folks. Because I agree with you. The last thing we want to do is in any way, believe me, as a queer woman of color, like, no. But I do think that I wanted to be able to summarize what the law is in a concise way is incredibly beneficial to, average Californians that are going to be implementing using this law.
One other point about this discussion of the utility of the backstop. I'm not arguing either way on whether to do it, but a backstop can also, if framed correctly, serve to future-proof the law.
This is the proper argument.
My sense is that there has been a lot of movement in the last couple of decades, especially around gender identity and expression. And that, California's done a good job of catching up to by amending the UNRU Act and the Fair Employment Housing Act and all those laws to include those categories. But it was necessary for them to take those steps to avoid any argument that they were excluded. You could draft a backstop with the basic structure of it is unlawful to discriminate on the basis of sex. Discrimination on the basis of sex includes discrimination based on any characteristic that is related to or derivative of biological sex, including but not limited to the whole catalog.
So
And
the first part would not be novel. The rest of it is.
But
To me, that's the important part.
the structure of it that I just laid out is what we use often when we want broadly inclusive laws that are future-proof, is to say, here's the principle. Here are the examples, okay? But the examples are not exclusive. There can be others. And so the list of examples serves to inform the understanding of the principle, but the principle is open-ended. So you make sure everybody that's currently needs to be covered is covered, and maybe others that we haven't conceived of the issue yet necessarily in a way that we will in a few years' time.
Does the audience member still have their hand up? Can we try that again?
Yes, should we try it again?
Can you unmute them? I see you, Ambassador.
Mr. Richardson, I apologize. I turned you off because your microphone was like grabbing the channel and making noise. But I am enabling you now, and if you unmute, I think you should be able to speak. You want to give it a shot? Well, perhaps I'll leave that open again, and if he's able to unmute.
See if you can break in.
While we're waiting, I am not opposed to what Commissioner Carrion has said. In fact, I'm very attracted to it. The reason I raised the existential issue is I think it's time to decide what we're actually doing. Because we've been fishtailing all the way back and forth across the freeway. And some of the spins and turns I find frightening because I'm old enough to recognize that social justice is tidal rather than inevitable. So as long as we're focused on what we're doing and everybody agrees that's the direction we're going in, I'm fine with that. We just need the definition. We need to know what we're doing.
Well, to me, my thought process on this has largely been proceeding kind of in the direction that Brian just described, because it flowed from our discussion about our initial definitional discussion of how we were going to define sex we decided to define that very broadly as,
Gorsuch was right.
yeah, gender defining characteristics writ large. And so, Article 1, Section 8 already bans discrimination on sex specifically. That's in addition to the equal protection guarantee. That's in addition to privileges and immunities. So I'm very comfortable with the degree of constitutional protection we have for equal protection in general and for sex specifically. If we want to unpack what our current understanding and our future-proof understanding of what sex should be defined as, like that to me is the one thing that makes sense here. And I would want to see the discussion move in that direction. But Mr. Richardson, are you still?
He's been enabled, but he's currently muted.
Okay. I don't want to forget about him.
Yeah.
So other thoughts from my colleagues while we're waiting for him to potentially jump?
Do we recognize him?
He's not showing up here on the,
It's not showing up on the screen here.
it's Mr. Richardson.
See if he's-
I can unmute him here. Let's
Give it a shot.
now try it.
He's still showing us muted on the screen.
This worked the last time. It's not working now.
Where's our tech person?
Well, I think the problem might be on the other end of this connection.
No, because.
Maybe he can type his comment.
We
Is there a
don't
way
have
for-
chat enabled.
Oh, we don't. have-
Yeah.
Okay.
Yeah, I've also promoted him to panelist. That's not working either.
I could try that. I think you maybe don't have the necessary privileges.
Yeah, up him to panelist.
Okay.
That worked the last
See what
time.
happens.
There's the guru.
Here it comes. Help us.
You might have to make him a panelist, I think.
We're trying to get Mr. Richardson so we can hear him. I've tried to unmute him, but it's not working.
He might be muted on his end.
And I tried promoting him to panelist.
Right.
That's not working either.
I'm gonna try that now to convert him to a
If
panelist.
someone's muted on their end, you can't really force.
The mute
their
just
mic.
went off.
Oh,
Well,
Mr. Richardson?
I'm trying to promote him to panelist. I disabled his talking and that's why the mute went away. It doesn't look like it's within my control.
are you able to send
Yeah,
someone a
talk to you.
message? Otherwise, like,
Are you turning it off? Because I'm turning it on.
Yeah, I was just allowing him.
Okay.
Might be since you turned it off.
is it gone now? Yeah,
I think he's rebooting himself.
Yeah, probably. We'll keep an eye out for him and see if we can enable that.
Well, so colleagues, how do you feel like it's, if I can kind of encapsulate the discussion so far, it seems like our work is to do something with the California version. And in our discussion of that, we decided that the ERA should be defined fairly broadly to include sex as an umbrella category, gender as a subcategory, and then variations on gender within those broad categories. And as Kristen has explained, there's already pretty good coverage constitutionally, statutorily, and in the case law in California for sex specifically. And it seems like the area in which we can drive positive change to law is unpacking or expanding or future-proofing the definition of sex and gender as we understand it, as it might be interpreted in the future. Folks feel like going in that direction. And that could be either a statutory change or a constitutional change that we propose.
Can I add one more thing, which is that doing so provides us with a vehicle for writing a scholarly argument.
Oh, my God.
I mean, our report and perhaps legislative findings can explain why we believe that it should be understood that way. And then that's, our writings are something that courts can notice.
I like that.
Don't threaten me with a good time. You use the scholarly word.
Are there any other projects you'd like to suggest?
Kristen, you and I will become close friends.
Thanks.
So it does seem like the commission is sort of coalescing around the idea of making more clear what sex includes without making that be exclusive.
So as not to narrow any. even in
Identify a
certain-
number of things that are within the umbrella and recognize that there are other things that may fall under there as well, and we're not closing that off. There has been some discussion about whether we might want to do that constitutionally or statutorily.
Right.
The staff's recommendation would be to focus on the statutes. The commission is just in a much better position to operate with respect to statutes than we are with respect to constitutional revisions.
Yes.
And so that would generally be the recommendation, but that's up to the commission. If we do want to pursue something constitutional, we recommend checking with legislative stakeholders to see.
I'm fine with that. I did want to make like one clarifying point about the way RIFRA was discussed in the memo. RIFRA doesn't, because it can't specify that strict scrutiny applies to constitutional claims. Because you can't set a constitutional standard review with a statute.
Yes, so I think I described it as quasi-constitutional at one point.
Yeah,
Because it
yeah,
is
yeah.
essentially trying to do exactly
Yeah.
what you're saying.
But really what it boils down to is RIFRA creates a statutory cause of action that imports a constitutional standard of
Strict
review.
scrutiny standard.
Yeah, we could do the same thing
Yep.
here.
Yeah,
And we ran across something like that in the chapter or article or whatever that
Right.
contains the
Right.
UNRU Act. There's a
Right.
provision in there
Right.
that uses a kind of strict scrutiny
Right.
standard for discrimination against minority groups, political participation.
I just want to make sure we're on the same page that by statute, we're not going to try to tell the courts, here's how you should interpret the Constitution, because it doesn't work that way.
No. One last comment on this one on my part is,
Yeah.
have we heard from entities, advocates regarding our work on this and what they prefer?
so the only letter that I got was an attachment to the supplement for the August memo. And so that was from the Feminist Majority Foundation. And they were one of the sponsors of the resolution. So, and they were responding specifically to the approaches presented in memo 2340 and how we would want to address any potential constitutional limitations that might restrict what we could do in this area. And they were generally in favor of the sort of broadest approach of identifying affirmative constitutional support for broad application of a sex equality principle. And
I'm not sure I know what that means.
so the idea would be we would set out arguments in favor of understanding the sex equality principle broadly
The scholarly article
and
argument, yeah.
identify as a compelling interest.
Yeah.
That, eliminating gender discrimination, like the things that have been in the case law, but trying to bring all of those arguments together in a single place, whether it be in the statute or in our narrative report, that would be something for the commission to decide as well.
And following up on that, can we seek advice from other entities?
Yeah, so.
I would like to do that.
Okay.
If
All right, so
There's-
I can report two things. One is the Bagley-Keene Act prohibits us from requiring that a person's participation in the meeting be acknowledged publicly. So I can't say anything about in general who's attending our meeting, but we do have somebody from one of the sponsoring groups who's watching. And so if she prefers to stay silent and just observe, that's perfectly fine.
Raise the hand.
There's a hand up, Darcy.
That's not what I'm talking about. There's somebody else, but I will enable Darcy Totten to speak, hopefully successfully. Since Darcy's a cat.
Oh, okay. I apologize for being a cat. I don't know how to turn on my video right now in this format, so I am not a cat.
Not a cat.
I just, so I am with the California Commission on the Status of Women and Girls. We met with them a year ago. We were very excited. We followed this with a great deal of interest. And while we don't have a particular recommendation, we are very excited to be helpful in ways that we can be. And the scholarly article track sounds very aligned with where we tend to fall on these issues. And we are happy to help however we can. So I just wanted to volunteer that.
Thank you.
Appreciate it.
Thank you.
All right.
Other comments or thoughts from my colleagues or from the audience?
No, nothing more.
Going
terms of
once,
minutes.
going twice. Kristen, do you feel like you have a direction?
So my general sense is that the commission wants to pursue a statutory reform that defines what we understand as the scope of sex to be inclusive but not exclusive. Whether or not we want to do a strict scrutiny standard, I don't know if that's something the commission has thoughts on right now, whether that would be something they would want to include in.
We at least have to talk about it.
Okay.
Yeah.
Like sex is a suspect class, so it's subject to strict scrutiny in California already.
Yes.
Since California doesn't do intermediate scrutiny, like it's pretty simple.
Yep.
I guess one
And it's not
other,
rational basis.
one other issue to think about is who does this statute apply to? If you're talking about equal protection, that's the state, but do you want
Could
this
make it private
principle to
right of action.
apply? Yeah, well, more broadly to private conduct,
Right.
like public accommodation laws do.
So,
Yes.
so we could go down the privacy route. We could do a PAGA cause of action. There's options to consider there.
And don't forget the scholarly.
We're gonna have a whole section on no
Very
service
scholarly.
sources and Justin generis, like it's gonna be great. It's gonna be a good time.
And then you'd also be going forward on phase 2, right?
Yeah, so part of that is really a broad outreach, because one of the
Yes.
things that we really need is we need for
Experts.
folks to tell us
Yeah.
where to be looking, particularly for the disparate impact piece.
Yeah.
Those things are not going to be obvious from the face of the statute. Identifying the discriminatory language might be a little bit more straightforward. Although our charge is broad and is not limited to statutes, it's also touching on case law and things like that, which may be a little bit harder to find all the pieces that may need to be addressed.
There's a few sort of obvious, usual suspect stakeholders in this, like Equality California comes to mind.
Yeah, so we did
Do
do
you know
some,
of anybody that does this kind of work that?
Yeah, there's a whole, so I believe
Yeah.
actually that Kristen already has a huge repertoire of,
Yeah.
I mean, I think many of us have given already some names.
Okay.
we
have
did do
another-
some broad outreach
We can do
initially,
another-
just to notify everyone of the study.
Right.
Kind of changing, or at least refining our direction, so
Yes.
maybe telling people what we're thinking now.
Yeah, so it may be worth also seeking out specific input from folks about where there might be problems and what.
We have another audience member that we're trying to promote.
Yeah, giving it a shot. Here she comes as a panelist. This is Betsy Butler.
Ms. Butler?
She's probably just transitioning to being a panelist, which may involve,
Clicking some buttons, huh?
clicking through for audio and video.
We can hear you.
Okay.
We can hear you. Go ahead.
Hi, everyone. Sorry. First of all, thank you again for your work. And, I've just been listening and thank you especially to Kristen for her time and effort and all this. And, I think you were kind of looking for some input from me just a bit ago. And I'm just kind of handing it over to you all. I'm glad I live in a state where we're pretty safe here, but are we safe enough? And is there equality and equity? I know Kathy Spiller, who's with the Feminist Majority, had shared some support for item 4 before. I think Kristen shared that with you at a meeting that I wasn't at. I don't remember, Kristen, can you remind me if you shared Kathy's preferences?
That was presented originally at the August meeting, but is also on the agenda for this meeting. So
Okay.
that,
The email, right?
Yeah. So, if you're going with option 2 and option 4, I'm just really handing it over to you. I do, I wasn't in the conversations when the senator did the legislation, so I don't know what her conversations were with Ledge Council or others about how to achieve it and federal versus state and all that. So maybe I could check in with her, with Senator Leyva, to see if there's additional items that she wants to bring forward at this time as you're making some decisions. So I don't know if that would be helpful.
Comments, yes.
Sounds good.
Yes.
Be a great
Great, thank
idea.
you.
Okay. All right. Well, I'll check in with her. And this meeting's obviously being recorded. So I
Yes.
will, when you guys send out the link to it, I'll forward it to the senator and see if she wants to come back with some updated information. And just also to weigh in on this. I mean, she's very busy. She's running a radio station, but she undoubtedly will want to weigh in on it, I would imagine.
We would appreciate the perspective. Thank you.
Okay. All right. And no, thank you for all your work on this really, really, really great to be a part of it. And hopefully things come of it. And again, we live in a great state and we're very grateful for that. And thank you for your help.
Thank you.
And I'll be
Thank
back in
you.
touch with Kristen about the Senator Leyva aspect.
Appreciate the follow-up.
Thank you.
Thank you.
Thank you.
Any other hands from the audience?
No, not that I'm seeing.
I think Kristen has some direction
Yeah.
and we'll take this up at a future time.
I think so.
Yeah, I don't think there's any formal decisions that I need to call for at this point.
It's more just general direction
Yeah.
on like what staff should be moving towards. And it's mostly consistent with what's been discussed before.
Yeah. And I don't think we're taking anything off the table for sure, but we kind of have a direction of what we want to look at next and what we want to explore and whether or not that might work to move forward. So.
Okay.
I appreciate the good discussion.
Anything else on that?
That is it.
That matter is concluded. Any further business?
There is no further business, so we could end the meeting here.
Wait,
What?
if I may interject for
may.
one moment,
Yes.
please. It's not official business, but this is finishing my second term here and I did not seek reappointment, but I wanted to express my absolute pleasure at serving with all of you. And Brian, you have impressed me continuously
Thank you.
with your work and your insight. And I love you because you are one of the greatest staffers I've ever had the opportunity to work with. So thank you. I'll miss you all, but I'll be keeping in touch. I'll be
Yeah.
checking it out. So, and best of luck to you, Sharon.
Thank you.
Really excited to have you come on board. Yeah, thank you for indulging me on that.
And we're really sad to lose you.
Yep.
You really are irreplaceable.
Thank you for your service.
Thank you.
Brian, on behalf of the commission, I hope you enjoy your gift. Are you pointing at Victor?
I'm pointing at Victor.
I'm pointing at Victor too. What do you?
Okay. I just want to say our appreciation of your work.
Absolutely.
And I've served with you for years. And I want to commend Brian on all of his work and to ask that you follow the example of Nate Sterling,
Uh-oh.
who has kept in touch with the commission for years and has been a friend and guide, even though he stepped off quite a long time ago. So the door is always welcome and we'd love to see you back. That's when we need it.
Yeah, well, I've told the staff that I'm available if they ever want to talk to me about anything where they think it'd be helpful to have my perspective. So informally, I'm a continuing advisor. Formally,
He's like, I'm out.
no retired annuitant.
Brian,
I can't wait to leave Steve out. I see him there.
Hiding.
on behalf of the commission, thank you for your service to
Yeah.
California. This
Yay.
meeting is concluded and I hand the gavel over to my successor.
Oh,
Yay.
wonderful. Thank you. Back in session. We have the afternoon.
Yes.
No, we don't.
Wait. Brian's like, I have a plane ticket.